Good morning, sir. Are you Luther Sharp?
Yes, ma'am.
Mr. Vasquez, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Sharp, in cause number 25, wait, are we going on count one?
Count one, Your Honor.
All right, hold on. Let me get that done. Okay, in 25 DCCR 0916, the state has elected to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from May 26th of 2025, and how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 15 years in prison, you can't appeal that. I can give you 15, I can give you less. It'll all be determined on the evidence and information that I receive at a sentencing hearing.
Luther Sharp just made a calculated choice. He's trusting one person with his fate. By pleading guilty and waiving his jury trial, he's handed the judge complete control. She can give him 15 years. She can give him less. But here's what most people miss. This isn't mercy. It's strategy. And the clock is already ticking on whether that strategy will pay off.
You have an absolute right to have a jury come in and do two things. The first is to determine if you're guilty or not. And the second is, if they find you guilty, then you could leave your punishment up to them. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am.
Also, part of that agreement is that the state would dismiss cause number 25. Y'all wrote C, but I think you meant DCCR.
That's correct, Judge.
DCCR 0917. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sharp is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing, and so the probation department can do a pre-sentence report. We'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Vasquez, and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Your Honor, can I speak?
Sure.
Would the court consider a bond reduction?
Not with a cap of 15 years in prison. No. You can go back with the bailiff.
Really? Let's do the questions. Consider me, you think about it about 3 seconds, Your Honor.
Well, I guess, yeah, I could have thought about it for a little bit longer, but thanks for asking, but no. Oh, you know what? Bring him back out here. I don't know.
5 seconds? It's too late for that.
Figured something. Figured she'd tonight.
Mr. Sharp, I want to make sure that you understand and know that I receive, the district attorney's office receives, your attorney will receive all of your disciplinary incident reports from the jail. I have 11 pages of them. So if you think you're going to come in and ask me for any type of consideration on that plea, my suggestion is between now and when you come back, I don't have any more added to this.
Yes, ma'am.
I don't have to take the 15 years.
Yes, ma'am.
We could go to trial, you could get worse.
Yes, ma'am.
A jury will see all of this.
Yes, ma'am.
You're too old for this nonsense.
Yes, ma'am.
All right, go back with the bailiff.
11 pages. That's how much trouble Luther Sharp has gotten into while waiting for sentencing. Fighting, disobedience, chaos behind bars. And now the judge has seen all of it. This is where plea deals unravel. This is where consideration disappears. Because in her eyes, he's not showing remorse. He's showing a pattern. And patterns don't get rewarded.
DCCR 0176, Mr. Williams is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, Mr. Williams, and I filed the motion in this case after I explained and sent Mr. Williams a communication explaining what he was subject to in terms of punishment and what the state has indicated their enhanced punishment range and a motion to accumulate coming on a jury trial. He immediately told me he did not want me represent him because I don't show his best interest. He would like to fire me, so.
You're court appointed, right?
That's right.
You don't get to fire your court appointed lawyer. You can fire someone you hire. Mr. Wilkerson is an excellent attorney. He handles many cases for all of us here in Jefferson County. If he's advising you of whatever your situation is, then your situation is what it is. So we can go through and what you're charged with and make sure we're all on the same. I feel like we've done that before because we've already had a plea bargain rejection, but let's do it again. It looks like you're charged, it's a third-degree felony, which means the punishment range is between 2 years and up to 10 years. However, it looks like, has there been, I don't see a notice filed of extraneous, but are there some that you
Yes.
anticipate filing?
Yes, Your Honor.
Mr. Smith?
Yes, Judge.
Two prior state
There's
judges.
Well, there's a third degree, excuse me, Judge.
Hold on just a second while they get this figured out, and then I'll let you ask any questions you have, okay?
No, that was me.
So Judge, there's a state jail for criminal negligence homicide. There's another state jail for attempting to take a weapon. And then there's the third degree that Mr. Smith mentioned. There are no other TDCJ convictions.
So the third-degree felony conviction, if true, would enhance your punishment in this case, if you were found guilty, to the second-degree range of punishment, which is between 2 years and up to 20 years. Do you understand that? Okay. And it looks like we previously did a plea bargain rejection, and at that time, the third-degree felony was checked off instead of the second-degree admonishment. But I do want to make sure you understand today that if you go to trial, and if that conviction for the third-degree felony, the state jails don't enhance you, but the third degree would to a second-degree felony range of punishment. It looks like that rejection was for a 4-year term in prison. Is that still the offer?
That was the offer as of this morning.
Okay, so the offer is for 4 years in prison. You already said that you didn't want that. If you want to change your mind after discussing your options with Mr. Wilkerson, then we can take care of that. If you don't, then we'll set your case for trial. Mr. Wilkerson will prepare for trial, and we'll get it taken care of as quickly as possible. Yes, sir.
There was one more thing. The state had indicated an intent to file a motion to accumulate. He just had an 8-year sentence on an MTRP.
If you recall, Judge, we had a contested motion to revoke probation with this as the allegation. We proved that up. You gave him an 8-year sentence.
Okay.
So that 4-year sentence that we had offered today was to run concurrently with that.
Okay.
If he rejects that, then we will file a motion to stack whatever he receives from the jury in this case on that 8 years that he's already served.
So I want you to understand, so the third degree conviction, is that something other than the conviction?
This is what happens when the law gets technical and when it matters most. The state wanted to enhance his sentence using a prior conviction, but the judge caught something the prosecutors didn't: timing. If the conviction happened after this offense, it can't be used to increase his punishment. One legal detail just saved this man years, maybe even a decade, and the entire courtroom just realized it.
The revocation, or that's the one that,
The revocation was for a injury to him. So that was,
the prior conviction that y'all are talking about, that third degree,
That's on the MTRP.
that's on the MTRP?
Yes.
And so does everyone agree that timing, though, the conviction of that,
I see what you're saying. I don't think that one does, but I think the 2 state jail felonies bump it up to a 2.
they don't do anything. State jails don't do anything to a TDC case. And if I convicted him on an MTRP after this offense date, then he wasn't convicted on the offense date, and so that doesn't make it sequential. Am I right?
I think you are right, Judge. So I do think it goes to the...
I don't disagree that there could potentially be a cumulative request, but I don't think it would enhance his punishment, because I think it has to be a prior felony conviction before the date of this offense. Help me out, am I right?
I
I'm
think
I'm looking at all the lawyers, everybody?
I think
Yeah?
you are, Judge. Yeah.
Okay, so forget everything we just said. The range of punishments between 2 years and up to 10 years in your case. The state's offered 4. You can take your 4, you can go to trial. Mr. Wilkerson will remain your attorney. So what do you,
I want to go to trial.
Okay.
And I want to see what is the outcome if I can get my own lawyer.
well, yeah, so you have the right to hire your own lawyer at any time. But because you're in custody, we're going to move forward with your case. I'm clearly going to appoint you someone. You're not just going to sit in jail without a lawyer. We're going to make sure you have representation, and your case is going to move along. So if your family or you has the funds to go hire someone, then by all means, you need to get them hired, and they can substitute in, and they need to get ready for trial also. Until or if that happens, if it doesn't, we're going forward, case will be on the trial docket, we're going to move forward. We're not going to keep putting it off for that to happen. If it happens, great, but as of right now, you're rejecting the 4. I also want to make sure you understand, Mr. Smith, is there any reason to believe that that offer of 4 would change?
No, Judge, and in fact, we had offered to dismiss the case against the co-defendant in this case for his plea in this case to run concurrently at the time he's already served. In fact, it would be for less time. So.
Okay, so I do want to make sure you understand that there's not going to be any new offers. The offer remains what it is, no matter who your lawyer is.
Yes, ma'am.
And that there is the potential for anything you get from a jury to be stacked on top of that 8 years that you already got. You understand that too? Okay, we'll get it set for trial. You can go back with the bailiff. And so I am going to deny the motion to withdraw. All right, so on John Jones, let's just go through rejections.
3 men, 3 different strategies. Luther Sharp bet on the judge's mercy, but his jail record may cost him everything. The second defendant tried to enhance his sentence and failed due to a technicality. And the third, he rejected 4 years, fired his lawyer, and demanded a trial, even though the offer won't get better, and the jury could stack more time on top of what he's already serving. In the end, courtroom strategy isn't just about the law. It's about knowing when to negotiate, when to fight, and when to accept reality. Some of these men understood that, others didn't, and now they'll live with the outcome.